Thank you very much, Honorable Chair and members. We will comment on 4 issues by way of preliminary matters. The first issue is the whole question of witnesses and witness statements. The second will be the question of the competence of the motion before you. The third will be the request we have made on adjusting some of the timelines. And of course, the last will be the issue mentioned by my learning senior, the question of summons to some persons. I want to begin with the question of the whole witness statements and the calling of witnesses. Honorable Chair, it is our application that you decline any request on the part of the mover to call as a witness any person whose either affidavit or sworn statement was not part of the motion before you. The reason we say that is 2 matters of principle. Number 1, you are here to investigate the motion as approved by the House. This committee has no power to interrogate any other material that was not before the House. The second reason of principle, Honorable Chair, is a question of fair trial. When this motion was approved and served upon the Honorable Cabinet Secretary, he was required to respond to the motion as placed before the House, as approved by the House. And now we are being told of endeavors to introduce additional material that he has not had the opportunity to read, to review, and to respond to. This matter, Honorable Chair, is not just a procedural issue. It is a question of fundamental justice that is governed by a whole regime of 5 different sets of laws. The first one being our Constitution, the second being the Fair Administrative Action Act, the third being the prevailing case law on this specific matter we are placing before you, the fourth being your standing orders, and the fifth being the rules of this committee itself. And it is our submission, as I hopefully show you shortly. Whichever of these regimes of law, and I've mentioned them in their hierarchy, whichever of them you look at, there is zero room for introducing extraneous material that was not part of the documents that were before the House when it appointed this committee. We'll begin with the Constitution, Honorable Chair and members. Article 50 of our Constitution has a right called fair trial. This right, Honorable Chair, includes, among other things, the right to confront and to respond, and more importantly, when you read Article 50, subparagraph 2J, the right to have the information and the allegations and the evidence against you in advance. Those are not my words. It is the words of our Constitution. The evidence must be submitted in advance so that, as a matter of fair trial, the person accused will have the opportunity to respond to all the allegations against him. This matter of fair trial is so important, Honorable Chair. It is one of the 3 rights in our Constitution that are absolute, which means they cannot be limited. This can be confirmed from Article 25 of our Constitution. It lists certain fundamental rights which cannot be limited. Not even Parliament can enact a law to limit those rights, and one of them is the right to a fair trial. This right is as old, Honorable Chair, given the type of legal system we have. It is as old as the year 1215, more than 800 years ago, when we had a document called the Magna Carta. Article 47 of our Constitution again talks about the right to a fair administrative action. I only mention this, Honorable Chair, because the communication from the Speaker to this committee said a number of things. One of them, of course, was that these proceedings are quasi-judicial, but for purposes of my submission, the Speaker also said in his communication to the House that the proceedings before you are governed by the Fair Administrative Action Act, which is the one that governs this whole question of fair procedure and whatnot. That brings me to the prevailing case law on this matter, Honorable Chair. Luckily, we are not bringing to you a matter that is new. This matter has preoccupied our country to a level that we had to appoint a 5-judge bench of the High Court sometime in 2015, when the Republic of Kenya at that time, beset with terrorist attacks, wanted to change the law on inquiries and criminal proceedings so as to tinker with this right to fair trial, so that the state could go to a court of law and introduce the evidence right at the eve of the trial, right at the very 11th hour. And we have a decision, I believe, petition number 628 of the year 2014. I said it's a 5-judge bench decision. And the issue in that case, which luckily my senior, Dr. Kamino, was actually the one arguing this point, and the court was happy to agree with him, that it is not permissible, even when the country is faced with existential threats like terrorism. You cannot do what the move of the motion now is attempting to do, which is to bring a motion to the House, have the motion approved by the House, sent to the committee, and then...
Madam Chair.
Yes, Honorable.
May I just inquire if we have this ruling before us? Is it in the bundle? Which bundle? Please point to us where it is.
The Honorable Chair have endeavored to print the relevant parts of that ruling. We didn't have it, of course, in advance because we had not noticed until last night very late that this issue would arise, because we were working on the assumption. I've just given to the Secretariat. It's a fairly long ruling, so I only bothered to print out the relevant parts, and I think it is highlighted in the document. It is at paragraph 346. And all we are saying, Honorable Chair, it is not every day problems like this, our Chief Justice appoints a bench of 5 judges. Usually the practice is 3 judges, but this was a matter that was so critical to the administration of justice in this country that the CJ had to constitute a bigger bench than usual of 5 judges. And the matter was settled. It is not a question of discretion. It is not a matter of us trying to balance this or that. It is there in black and white from the High Court, which is the court charged with interpreting our Bill of Rights. And all we are saying is that it is not permissible. And the reason it is not permissible, Honorable Chair, I told you this matter is as old as 800 years. Back then, there used to be controversial methods of inquiry in which evidence was withheld until the last minute. People used to be tried before an institution called Star Chamber using very unorthodox means. In short, trials 800 years ago used to happen, for lack of a better word, if I may say, where the accuser would keep surprising you, like a conjurer pulling out rabbits from his trench coat. And because this matter was so critical, Honorable Chair, it was the subject of revolutions in England, no less than 3 revolutions. In one of them, the monarch actually lost his head, and all we are trying to do is to tell you, it is not possible. It does not even arise for consideration. Lastly, Chair, you have your standing orders. Standing Order 64 says that by the time the motion comes to the Speaker for approval, it should already be accompanied by the witness statements, by sworn statements, and all other items of evidence. Those are not my words. The thinking must be that by the time you make an allegation as serious as the ones before you, you had better have done your homework, you had better have done all your preparation, and you had better put forward all the material upfront so that the accused person will have then the opportunity to respond. And of course, your rules themselves, which is Rule 2, if I'm not mistaken, I am being guided by Boniface that I might be mistaken, but you've already adopted the rule again. Rule 7, consistent with your standing orders, which says that, if I may read, in presenting evidence, the sponsor of the motion shall not introduce any new evidence that was not part of the allegations against the Cabinet Secretary. And very lastly,
try to conclude.
Yes, to conclude, Honorable Chair, there is a further practical difficulty we have with these so-called witness statements. As I told you, we were only told this last evening. The Cabinet Secretary is unable, as we speak, to confirm whether, one, the so-called witnesses are persons who actually registered for the fertilizer program at the inquiry, whether, as a matter of fact, they obtained fertilizer, and from which depot, and on what date. So we are completely unable, even if we so wished, given the timelines we are working on, to respond to whatever those witnesses may purport to say. And the very last point, Honorable Chair, you must be told what was the difficulty in putting up these witness statements, in getting these guys to swear their witness statements according to Standing Order 64 at the time the motion was brought before the House. I have not heard them attempt to tell you either these people were nowhere to be found, we're trying to trace them, we couldn't, one of them was in hospital or something like that. No reason has been advanced why there was non-compliance with Standing Order number 64. On the contrary, what you have is a mover that assumes, like I kept saying last night, they have a right as a matter of course to keep pulling these surprises. And for those reasons, Honorable Chair, we urge you to reject that request for additional witnesses. We will deal with the question of the defective affidavit, given that I've already run out of my time. When we respond to the case, I will still beseech you to give directions on the other requests we had made, which are in writing anyway, and on the questions of summons. The parties cannot be the ones requesting you to summon anyone. It has to be the select committee exercising its own independent mind to decide we need to hear from so and so. It cannot be me, it cannot be my learned friend telling you, insisting or pushing you, summon so and so. Because a person summoned is not a witness of the Cabinet Secretary and is not a witness of the move of the motion. They are just someone summoned by the committee to enable it to understand something. Thank you.
Thank you.